Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving secured lending and insolvency, a key topic in business law under FLK1. Let's dive in. A company created a fixed charge in favor of a trade supplier. The charge was not registered at company's house. 5 years later, the company entered into a debenture with a bank, creating another fixed charge over the same assets as security for a bank loan. Before executing the debenture, the company informed the bank that the trade supplier already held a fixed charge over its assets. The bank's charge was duly executed and registered at company's house. 10 months later, the company entered administration. It still owed money to both the trade supplier and the bank. How is the administrator likely to deal with the company's assets and liabilities? A. The administrator will give priority to the trade supplier's charge, as it was created earlier. B. The administrator will treat both charges equally, since the bank had notice of the trade supplier's charge. C. The administrator will ignore both charges and treat all creditors on a pari passu basis. D. The administrator will give priority to the bank's charge, as the trade supplier's charge is void for non-registration. E. The administrator will set aside the bank's charge due to its knowledge of the earlier unregistered charge. The best answer is D. The administrator will give priority to the bank's charge, as the trade supplier's charge is void for non-registration. Under Section 859H of the Companies Act 2006, a registrable charge must be delivered to company's house within 21 days of its creation. If it is not, the charge is void against any liquidator, administrator, or creditor. It remains valid only between the company and the charge holder. Actual notice of the unregistered charge is irrelevant. Registration is the legal requirement. In this case, the trade supplier's charge was never registered, so it is void against the administrator. The bank's charge was registered properly, so it is enforceable. The administrator will therefore treat the bank as a secured creditor and the trade supplier as an unsecured creditor. Scenario 2. A company created a fixed charge in favor of a trade supplier on March 3, 2024. The charge was registered at company's house on March 20, 2024. On September 9, 2024, the company executed a debenture in favor of a bank. The bank's charge was registered at company's house on September 29, 2024. On November 15, 2024, while insolvent, the company repaid a substantial portion of its debt to the trade supplier. The company entered administration on February 9, 2025. Outstanding sums remain due to both the trade supplier and the bank. How is the administrator likely to deal with the company's assets and liabilities? A. The administrator will honor the repayment made to the trade supplier because the charge was created first. B. The administrator will treat both fixed charges equally, as both were validly registered. C. The administrator will apply to set aside both charges and the repayment to the trade supplier, and distribute assets on a pari passu basis to all creditors. D. The administrator will disregard both charges as they were registered out of time and distribute assets on a pari passu basis to all creditors. E. The administrator will apply to set aside the repayment to the trade supplier as a voidable preference, and treat both charges as valid. The best answer is E. The administrator will apply to set aside the repayment to the trade supplier as a voidable preference. Under Section 239 of the Insolvency Act 1986, a company is considered to have given a voidable preference if it took action, such as repayment, in favor of one creditor, while insolvent or becoming insolvent as a result, within 6 months of entering administration, or 2 years if the creditor is a connected person, and the company was influenced by a desire to prefer that creditor over others. Here, all the criteria are met. The company repaid the trade supplier on November 15, 2024 while insolvent. It entered administration on February 9, 2025, within 6 months. This repayment improved the trade supplier's position compared to other creditors. The administrator may therefore apply to the court to set aside the repayment and restore the funds to the insolvent estate, so they can be distributed according to statutory order of priority. Scenario 3. A company gave a fixed charge over all its assets to a trade supplier on March 3, 2024. That charge included a clause saying the company was not allowed to create any further charges in favor of third parties. On September 9, 2024, the company gave another fixed charge over the same assets to a bank. The company's sole director also gave a personal guarantee for the bank's loan. Both charges were properly registered at company's house within the required time. On November 15, 2024, while the company was insolvent, it paid a large bonus to the sole director. The company went into administration on June 15, 2025. It still owed money to both the trade supplier and the bank. How is the administrator likely to deal with the company's assets and liabilities? A. The administrator will treat both charges as valid and may apply to set aside the director's bonus as preference. B. The administrator will give priority to the trade supplier's charge because of the earlier creation and restrictive covenant. C. The administrator will disregard the bank's charge due to the company's breach of the trade supplier's restriction, and only enforce the personal guarantee and trade supplier's charge. D. The administrator will treat both charges and bonus as valid and enforce the personal guarantee to satisfy the debt. E. The administrator may apply to set aside the director's bonus, prioritas repayment to the trade supplier due to the restrictive clause, and enforce personal guarantee to pay bank's debt. The best answer is A. The administrator will treat both charges as valid and may apply to set aside the director's bonus as preference. Validity of charges. Even though the trade supplier's charge included a contractual restriction on further charges, this does not invalidate the bank's later charge. Both were properly registered and are valid as against the administrator. Contractual restrictions. The clause in the supplier's charge gives rise to contractual rights, possibly allowing the supplier to sue the company for breach, but it does not affect the validity or enforceability of the bank's charge under insolvency law. Director's bonus. The bonus was paid while the company was insolvent to a connected person, the sole director, within 2 years of entering administration. This makes the bonus potentially challengeable under Section 239, preference, or Section 238, transaction at an undervalue, of the Insolvency Act 1986. The administrator is likely to seek to set aside the bonus to recover funds for creditors. This table highlights 3 key legal principles under English company and insolvency law. First, a registrable charge must be filed at company's house within 21 days. If not, it is void against an administrator, liquidator, or creditors, though still valid between the company and the charge holder. Second, a payment made to a creditor within 6 months before insolvency may be set aside as a voidable preference if the company was motivated by a desire to favor that creditor. Third, a clause prohibiting further charges does not invalidate a subsequent properly registered charge, and payments made to directors within 2 years of insolvency may be challenged as either preferences or transactions at an undervalue. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.